On Wednesday, Ghana walked out onto a pitch in Toronto for their opening match of the 2026 World Cup. They beat Panama 1-0. It should have been a moment of pure celebration for Ghanaian football, and in many ways it was. But there was an empty space in that squad that every football fan watching closely would have noticed. Thomas Partey, one of Ghana's most experienced and accomplished midfielders, a player who spent 5 years at one of the Premier League's biggest clubs, was not on the team sheet. He was not injured. He was not suspended by his club or by Ghana's federation for football reasons. He was not in Toronto at all. He could not be, because days before the match, a Canadian federal judge rejected an appeal that would have allowed Thomas Partey to enter Canada, a country he needed to enter to play in the World Cup his national team had qualified for. The reason he was rejected entry is at the center of one of the most serious and uncomfortable stories of this entire World Cup. Thomas Partey is currently awaiting trial in Britain on 7 counts of rape and 1 count of sexual assault involving multiple women, dating back to his time playing for Arsenal between 2020 and 2025. He has pleaded not guilty. The trial has not yet taken place. Under the legal systems of Britain, Canada, and most of the democratic world, Thomas Partey is presumed innocent until proven guilty in a court of law. That presumption matters. It is one of the foundational principles of justice, and nothing in this video is intended to suggest otherwise. But the question this video is asking is not about Thomas Partey's guilt or innocence. That question belongs in a British courtroom, and it will be answered there, not by football pundits or YouTube channels. The question this video is asking is about FIFA, about football's governing bodies, about what it means for a national football federation to select a player facing these specific charges for the biggest tournament in the sport, what it means for a host nation's courts to step in and make a decision that football's own governing bodies apparently were not prepared to make themselves, and about FIFA's near-total silence throughout the entire situation. I am MB, this is House of MB. And today we are examining a story that says less about one player's legal situation and more about how football as an institution handles serious allegations against its biggest stars, a theme that, as longtime viewers of this channel know, connects directly to patterns we have documented across multiple videos about how FIFA operates when commercial interests and difficult realities collide. Let us start with the facts of the legal situation, because precision matters enormously in a story like this. Thomas Partey was charged in August 2025 with multiple counts of rape and 1 count of sexual assault. The charges relate to allegations made by multiple women and relate to incidents that reportedly occurred during the period Partey played for Arsenal in the Premier League between 2020 and 2025. Partey has pleaded not guilty to all charges. He continued playing professional football following the charges being filed, eventually moving from Arsenal to Villarreal in Spain in the summer transfer window. His trial in Britain has been scheduled, but as of the World Cup taking place, it had not yet occurred, meaning the legal process that will determine guilt or innocence remains ongoing and unresolved. This is the legal reality. A serious criminal case, multiple counts, multiple alleged victims, a not guilty plea, and a trial that has not yet concluded. Now let us talk about Canada's decision, because this is where the story becomes specifically relevant to the World Cup, and where the most significant and surprising intervention in this entire saga took place. Ghana's opening World Cup match was scheduled to be played in Toronto, Canada, one of the host nations for this expanded 48-team tournament. For Partey to play in that match, he needed to be able to legally enter Canada. Canadian immigration authorities denied him entry. Partey's legal team appealed this decision. A Canadian federal judge heard the appeal and rejected it, ruling that Partey would not be permitted to enter Canada while he awaits trial on the pending charges. Partey's lawyer made an argument in that appeal that is worth examining closely because it reveals something important about how football's institutions think about situations like this. The lawyer argued that Canada, as a World Cup host nation, had what was described as a public interest in allowing the orderly participation of accredited national team athletes. Read that argument again. The argument being made was not that Partey should be allowed entry because the allegations against him were weak, or because there was reason to doubt the charges, or because of any factor related to the actual legal case. The argument was that Canada's interest in the World Cup running smoothly, its interest in accredited athletes being able to participate in an orderly fashion, should outweigh whatever concerns Canadian immigration authorities had about admitting a man facing 7 counts of rape into the country. A Canadian federal judge rejected that argument. The ruling meant Partey missed Ghana's opening match. This is, in itself, a remarkable moment. A national court system, not FIFA, not Ghana's football federation, not any football governing body, made the determination that public interest and serious pending criminal charges of this nature meant a player should not be admitted to participate in the World Cup. The football institutions involved did not make that call. The Canadian judicial system did. Now let us talk about Ghana's federation, because their decision to include Partey in the World Cup squad in the first place is a critical part of this story. Ghana's Football Federation selected Thomas Partey for their 26-man World Cup squad, despite the pending charges being a matter of significant public record by the time squad selections were finalized. This was not a secret. The charges had been reported extensively by British and international media throughout 2025. Ghana's federation, with full knowledge of the situation, decided that Partey's footballing ability and experience were valuable enough to the national team's World Cup campaign to include him in the squad regardless. This decision reflects a pattern that extends well beyond Ghana specifically, a pattern in which football institutions, when faced with serious allegations against talented players, frequently choose to continue fielding those players unless or until a legal process produces an actual conviction, treating the presumption of innocence as effectively a presumption of full footballing eligibility with no intermediate considerations. There is a genuine and difficult tension here that deserves to be acknowledged honestly. The presumption of innocence is a vital legal principle, and a person facing charges, even serious charges, has not been convicted of anything, and in many cases never will be. People are sometimes falsely accused. Football federations, like employers in any field, face genuinely difficult questions about how to treat employees facing pending allegations that have not been legally resolved. But there is also a meaningful difference between a private employer's internal employment decisions and the symbolic weight of a national football federation choosing to put a player facing 7 counts of rape into the uniform representing their entire country on the biggest stage in the sport, watched by hundreds of millions of people, including statistically an enormous number of survivors of sexual violence around the world. That symbolic weight is not nothing, and it is a weight that Ghana's federation chose to carry by selecting Partey, that FIFA chose to permit by not establishing any conduct-based eligibility criteria that would have addressed a situation like this, and that ultimately it took a Canadian federal court, an institution entirely outside football, to actually act on. Which brings us to FIFA's role in all of this, or more precisely, FIFA's near-total absence from this story. Throughout the entire saga, the charges becoming public in 2025, Partey's selection for Ghana's World Cup squad, the Canadian court case, the ruling that kept him out of Ghana's opening match, FIFA, as an organization, has said remarkably little. FIFA has extensive disciplinary codes covering on-field conduct. We discussed in a previous video on this channel how rigorously or selectively those codes get applied to violent conduct on the pitch. But FIFA's framework for addressing serious off-field criminal allegations against players selected to represent their countries at FIFA's own showcase tournament is far less developed, and FIFA's public engagement with this specific situation has been minimal. FIFA did not publicly comment on Ghana's decision to select Partey. FIFA did not publicly comment on the Canadian court's ruling, despite that ruling directly affecting participation in FIFA's own tournament, hosted in part by a nation FIFA partnered with specifically for this event. FIFA allowed national federations and national courts to navigate an extraordinarily sensitive situation entirely on their own, without providing any clear institutional guidance or position. This silence is, in its own way, a choice. And it fits a pattern we have documented repeatedly on this channel. FIFA tends to engage actively and decisively when issues directly threaten the commercial machinery of its tournaments. Broadcasting deals, sponsorship relationships, hosting arrangements. FIFA tends to stay notably quiet when issues are about something else entirely: human welfare, accountability, the symbolic and ethical dimensions of how football represents itself to the billions of people who watch it. We saw this pattern with the migrant workers who built Qatar's World Cup infrastructure. We saw it with how FIFA's disciplinary code gets applied differently depending on a player's commercial significance. And we are seeing it again here, in FIFA's conspicuous silence about a situation that a federal court, in one of FIFA's own host nations, felt compelled to directly intervene in. This case also connects to a broader and uncomfortable conversation that has been growing across professional sports for years, a conversation about how sporting institutions handle serious allegations against star athletes and the gap that frequently exists between what a sports institutions are willing to act on and what the legal system or simple public conscience suggests should happen. Other sports have faced similar reckonings. Football, given its status as the most popular and most watched sport on Earth, faces this question on perhaps the largest possible stage: a World Cup watched by well over 1 billion people, featuring a player whose presence or absence in any given match became a matter that a federal court, not a football body, had to resolve. What happens now? Partey remains part of Ghana's broader World Cup squad, even though he was unable to enter Canada for the opening match. Ghana's subsequent matches and the venues in which they are played will determine whether he is able to participate at all during this tournament, a logistical and legal question that will continue to unfold as the tournament progresses, dependent on Canadian and potentially other host nations' immigration decisions, rather than on any football-specific determination. His trial in Britain remains pending. Its outcome, whichever way it goes, will be the actual legal resolution of the underlying allegations, and it deserves to be allowed to proceed through Britain's justice system without footballing considerations distorting that process in either direction. But regardless of how that trial concludes, the questions this World Cup situation has already raised about football's institutional readiness to handle situations like this will not go away. Should national federations have clearer guidelines about selecting players facing serious pending criminal charges for major tournaments? Should FIFA itself establish clearer conduct-related eligibility frameworks that address situations beyond on-field disciplinary matters? Should the symbolic weight of representing one's country at the World Cup carry considerations beyond pure footballing merit, when serious unresolved allegations are part of the public record? These are not easy questions, and this video does not pretend to have simple answers to them. What this video does say clearly is this: football, as an institution, largely avoided having to answer these questions directly in this case. It was a court in Canada, an institution entirely outside football's governance structures, that ultimately made the consequential decision. FIFA, the organization that exists specifically to govern this sport at its highest level, mostly stayed silent and let immigration courts handle a question that, in a more accountable sporting institution, might have been addressed through football's own governance processes well before a World Cup squad was ever announced. That is the nightmare this story represents. Not just the specific and serious allegations Thomas Partey faces, which will be resolved in a British courtroom, but the broader picture of an institution that, when faced with one of the most difficult and consequential questions a sport can confront, chose silence over engagement and let the absence of clear answers become, by default, FIFA's actual position. I am MB. This is House of MB. This is a difficult and sensitive story, and we have tried to handle it with the seriousness it deserves, focusing on facts, on institutional accountability, and on the questions football needs to answer, rather than on speculation about a legal case that is still ongoing. If this video helped you understand this situation more clearly, share it, subscribe, hit the bell, and I will see you in the next one.